There are certain time limits in which you can bring a claim. These time limits are governed by statute, namely the Limitation Act 1980. Limitations on the time in which a claim can be brought exist to ensure that the claims are not too old when they reach court, and to give certainty to the parties and to prevent prejudice. Time starts to run the day after the injury. In clinical negligence, the general rule is that court proceedings must be issued within 3 years from the date upon which you knew, or ought reasonably to have known, that you suffered an injury as a result of negligence. This is because a claim arises when you suffer an injury. So if you are a victim of substandard care, but you do not suffer an injury or loss, then the cause of action is not complete. For example, in the medical context, breach of duty is treatment or care falling below the standard of a competent or responsible medical practitioner in the relevant field of medicine. Treatment or care which is unusual or unconventional is not negligence if there is a reputable body, albeit small, of medical opinion that approves it. It is not enough to simply prove that the care was of a poor standard. It must also be proved that the poor care has caused identifiable injury and loss. There are cases in which a patient can prove that the doctor was negligent, but even if the best care had been given, this would not have made any difference. This may arise, for example, in delayed diagnosis of cancer or birth injury cases. There are other cases in which an entirely different cause for the injury is found, which is unrelated to the negligence. A patient who cannot prove both that the care was of a poor standard and that the identified negligence caused the injury will not win their case. If a doctor is rude or indifferent, that in itself is not negligence. In the case of a fatality, the 3-year time limit runs from the date of death, assuming there was a right of action at the time of death. If there was no right to bring a claim at the time of death, then there is no claim. The limitation clock does not start ticking. In the case of a child, the 3-year time limit does not begin until they reach the age of 18, meaning that the limitation period will expire on their 21st birthday. Special rules apply to those patients who lack the capacity to conduct legal proceedings when they suffer an injury. The limitation period does not start to run until they gain capacity. So if they never gain capacity, then limitation never starts to run. But if they lose capacity again, limitation does not stop running. Nor does limitation stop running if a person has capacity at the time of the injury and then loses capacity at a later date. In practice, it may be possible to bring a claim outside of the limitation period, but the Limitation Act provides the defendant with a statutory defence to prevent such a claim. And whilst the defendant can agree not to rely on the protection that the Limitation Act affords them and to agree an extension of time, in reality this is not usually given when limitation has already expired. The court does have a discretion to allow a claim to proceed even though it is outside of the 3-year time limit. However, there are no clear guidelines as to what acceptable reasons for delay or what would be an acceptable period of delay, and much depends upon the individual circumstances of the case, and it is not widely given.